Welcome to today's episode. We are honored to host a distinguished guest whose career in law and justice spans over 3 decades. Justice William Ouko, a highly respected Kenyan lawyer and judge, currently serving as a judge in the Supreme Court of Kenya. Before joining the Supreme Court of Kenya, he served as the president of the Court of Appeal and as a judge in the High Court of Kenya, where his leadership and judicial wisdom shaped the course of justice in the country. In this conversation, we will dive into his remarkable journey through the judicial, his reflection on leadership within the courts, and his vision for justice and jurisprudence in Kenya. Join us as we sit down with Justice William Ouko to explore the life and insight of one of the nation's finest judicial minds. Ladies and gentlemen, I'm Deborah Gishuru, and this is the Resolution Room. Justice Ouko, thank you so much for joining us today. It's such a great honor to just have this conversation with you and just looking at your journey. You started as a court administrator and you became a judge of the High Court and a president of the Court of Appeal and now a judge of the Supreme Court. We are honored for your insights and just for you to share really what this journey really has been for you. So as the Resolution Podcast, karibu sana.
Thank you, and welcome to my chambers, and thank you for having me on this podcast.
Thank you so much.
And just a correction, I didn't start as a court administrator. I started at the lowest level of magistracy as a district magistrate too.
Oh, wow.
Yeah, then became a deputy registrar.
Yeah.
After being a resident magistrate,
Yeah.
then registrar, which is currently chief registrar of the judiciary, a similar position. Of course, before that I was chief court administrator, and then of course High Court, Court of Appeal, and now Supreme Court. Yes, so
Wow.
that's my journey.
That's one journey.
Yeah, from 1987.
Wow. So was law always the career for you? Was it something you always wanted to aspire to be?
As you grow up, you keep changing your mind. You can't believe I wanted to be, those truck drivers of garbage in the city of Nairobi in the 70s. Of course, then you keep changing your career as you grow. But from my family, my big brothers studied in some of the most prestigious schools, Maseno, Morehouse in the States, and Harvard. And so that inspired me quite a bit. And then, of course, in the village where I come, there were very many lawyers who were in private practice, some even rose to become judges. Some were top scholars in the university where I went, University of Nairobi. And all that inspired me to take this career.
What was a pivotal moment in your childhood and growing up that really pushed you towards being a judge?
It was in 1974, I lost my big brother under very unclear circumstances. He was murdered, and my dad thought that the investigations were not properly done because the suspect was acquitted on account of lack of evidence. And so my dad kept urging me to be a policeman, to be an investigator. And deep down, I thought to be a legal person who would achieve what my dad wanted me to be, rather than be a police officer. Yeah, so that's one of the reasons why I thought I would take this path. But I'll surprise you, I also trained as a police officer.
Wow.
But briefly as a Kenya Police Reserve.
Yes. Okay. So law was always the thing for you?
It was.
Yeah.
I never thought of being a doctor or any other profession or engineering, so it was always law. And when I did my A-levels, a group of us, we developed an acronym LON, which stood for Law or Nothing. and that was our guiding light. Yes.
Wow, that's amazing. I'm actually want to ask, like, before, even when you were still young, in your formative years and your formative stage, what was your family like? What was your upbringing like?
Yeah, my parents, I grew up in a polygamous family. I had two stepmothers, and my mother and my dad were quite strict people. They were church people. And so I grew up in such a background, and I had much older brothers, the ones who went to Morehouse, Harvard. They were much older, and so there was always some discipline around me. And I grew up, when I lost my parents, I stayed with my sister, who was also a disciplinarian, and so I grew up in a very strict environment. Yeah.
And now that you've served in different courts, what are some of those moments that really have stood out for you? Some cases or even stories that really have formed your decisions and even formed the person that you are today?
Yes, as I said, I did nearly 20 years in administration, court administration. I sat in court from 2001. The rest of the period since I joined in 87, briefly 2 years in court as a magistrate, and then the rest I spent in administration. And there are many, many things that have shaped my outlook to this moment. For your information, I'm writing a book in which I'm highlighting some of the high moments on the bench, and some of the low moments on the bench, and there are very many. So wait and read the book.
Okay. Most definitely, we will stay tuned for the book.
Right.
But arbitration has become such an important part of Kenya's commercial justice system. How did you first interact with actually arbitration?
Again, I'll take you back to my formative years and my days as an administrator in the court system. And it was all in this building. This is where I started as a magistrate. And this is where I became the administrator and worked here also in the Court of Appeal. But as an administrator, down the road, down this corridor, there was a judge called Justice Powell. He was sick, and he was dealing with civil cases, but he had a style of dealing with commercial cases. Bank loans, he had a way of determining such cases, in the sense that he would simply ask the plaintiff, normally the borrower, whether he ever borrowed the money from the bank. And if the answer was yes, he recorded that and asked the borrower again, so why are you in court? Then the borrower would say, I am disputing the interest. So you would enter judgment on the principal and go for trial on the interest. And banks found that very easy to deal with. In fact, many times the banks would agree to have the matter settled on account of principal. So they would rather get the principal and forgo the interest, and that really helped. And because we had such a big number of backlog in cases, so that really helped. And the banks then helped us as a judiciary to acquire, or rather to renovate, a government building near Milimani Commercial Court, right opposite. It was called Wajiri House. It's also the original Milimani court. So that was where the first commercial court was established, and that's when we started dealing seriously with the arbitration. Yes.
For many years, the judiciary has been a guardian for arbitration. How do you see the court's role in actually building the respect for arbitration, autonomy in upholding justice?
The courts, after the law was passed. I mean, we have always had loan arbitration from, if you go back to independent days, you'll find we always had an arbitration law. But from 1996, and this Judge Powell was there, I think, in 1993, 94, before the current Arbitration Act. The role of the court is very, very clear. It's circumscribed. It's limited. But that role is so critical because it meets the principles of finality of arbitration. It meets the principle of limited intervention by courts, and it also emphasizes the speed at which arbitration ought to be done. So the court's role is under Section 35, very, very clear, of the Arbitration Act.
You talked about the limited access from the court. How then do you know when to intervene in an arbitral award? How then do you determine when to step in, when not to?
Yeah, the parameters are very clear. Although under Section 35, you will find there are just two broad ones, but overall, I think 7. Yeah, but broadly, you will intervene if, for instance, one of the parties to arbitration had no capacity, where there is a claim that the award was procured through fraud and corruption. And so the parameters are spelled out, and that's the only time courts can intervene. Yeah, we do not intervene willy-nilly like in the past. It is now very, very clear that the circumstances under which courts intervene are set out in law.
Right now arbitration has such a great influence, and there's a lot of cases on commercial, even construction matters. How has that shaped the commercial jurisprudence with arbitration?
Yes, in the past there was confusion in the sense that there were two schools of thought. One school of thought was to the effect that courts could intervene at any point, any time, on anything. And then the other school of thought was that the court's intervention was limited. And so 3 cases ended up in the apex court. If you recall, the case of Nutu Agrobet, the case of Synergy, and the case of Yokan. Those 3 cases have now settled the law. We do not expect any new areas on this. The Supreme Court has now settled the level of intervention by courts. And so this ought now to make commercial arbitration easier, knowing that apart from enforcement and recognition of awards, the court will only intervene only to set aside on specific grounds.
Yeah.
Yes.
How do you uphold integrity in arbitration matters, mostly in commercial matters? How do you uphold the integrity of the arbitrators and also just the practice?
Yeah, integrity is important in arbitration, extremely important. And if we want Kenya to be a hub of arbitration in the region, in the continent, in the world, then we must uphold integrity. And currently, from the cases that I know, there's misuse of the process where parties come to court with such frivolous applications just to delay the award. And so the courts again are very, very firm. Where there's misuse of the process, the courts have stood firm and have dismissed such applications. Yes.
How can the judiciary ensure accountability while respecting the confidentiality and autonomy of the arbitral process?
Again, yes, accountability in arbitration is critical, and the court will ensure that the arbitrators comply with the law, and at any time that there is no compliance with the law, the courts will strike down any award that is granted where either the procedure was not followed or the award was not properly deserved. But the court will not substitute itself, its judgment or its opinion with that of the arbitrator. It's none of the court's business to bring in an aspect that is outside Section 35. Yes.
Laws are always being made every day, and I believe judges play such a fundamental role in the shaping laws and how laws are also interpreted. How do you balance between jurisprudence and precedents? How do you form your own precedent?
People say that today there are three people who make laws. The one that is recognized in the Constitution is the legislature.
Yeah.
And then today again, the Constitution allows the president, if he's not happy with the bill that has been enacted, that has been proposed, while giving his assent, he can decline to give assent and send a memorandum to Parliament explaining why. So in that sense, you can say the president takes part in the making of the law. And then of course the courts also decide cases sometimes, nullifying certain provisions of the statute or the entire statute sometimes. Yeah. And in that sense, then the courts also make the law. But there must be a balance. When you do this, you make sure that you do not interfere when the process is still ongoing in Parliament, because then that will be interfering with the parliamentary process that can only be interfered with when they conclude the enactment of the law.
So what principles in your cases have you used, actually?
I mean, of course, we all know about separation of powers. Mm-hmm. Yeah, Montesquieu, yes. That each of the three arms have different roles to play. So what guides us is, has Parliament made this law consistently with the Constitution? So if a law is made inconsistent with the Constitution, then the courts have a duty and a role to say so and to strike down such a law. If a law is made that violates some rights, again, the courts will step in.
I look around your office and a couple of things stand out for me is the portraits on the wall. And actually I was being told that these portraits have moved with you from office to office. What is the sentimental value there?
Oh, okay. There's a portrait that is in every office. You know which one? Yeah. The one for the head of state. Yes. But the rest are about just what I believe in. Yeah. I believe in justice. Mm-hmm. I believe in fairness. And so the portrait behind you is of a judge in deep thought, mm-hmm. Reading. That's what we do on a daily basis. You'll never find a judge lazing about whenever they have a free time. Yeah. It is to their work. So that's the one of a judge, an English judge, no name, because it's just a sketch. The other one is a doc brief. Those are lawyers in the courts in the UK, where they sit, and when a case comes up and you need somebody to do a pro bono work, or it's a question that would require some lawyer to represent somebody who appears in person, then the court would pick one of them to represent them. So that's the essence. I've had I've moved with all this from chamber to chamber ever since I joined the bench. Yes. And the other one really just hunting with the hounds. Yes. Yeah. And of course my daughter who has taken my line, yeah. And then my other daughters are behind me. Yeah. Yes.
How do you feel about your daughter stepping up and following your footsteps in the legal profession?
I can say I never forced her to, but she's my first born daughter, and I think as she grew up, how she enjoyed how I was working. But at that time, I was in administration, but she interacted quite a bit with the lawyers and judges, and that may have inspired her. And so I didn't force her to follow my footsteps. So she just thought it was the right thing, and she is enjoying it.
Your book collection is actually the first thing I noticed when I entered.
Yeah.
This for sure tells me you're a reader.
Yes.
But all these books, have you gone with them? Have you moved with each one of them? Have you read them?
Yes. Yes. Again, as I said, we do a lot of reading, a lot, and nobody will tell you that you have read all these books. As a lawyer, you know, we only deal with references. So if I have to find a decision in 1943, then I just go to that decision. I don't have to read the entire book. And so you might find that I have not read half of them. That's the honest thing. Yeah. But now with technology, I hardly go here. Because I can get a 1943 law report online. Yeah, so I work with my library now in a small iPad. Yeah, but I've worked with these books, and I have a similar shelf in the house in my study with books. Before, I would flip through and read through, but now it's so easy to just do it online.
What do you enjoy doing when you're not in your chambers and you're not reading and you're not looking at cases? What brings you rest?
Oh, I read and read and read, and I read mostly biographies, autobiographies, and I also read law-related books. I used to play lawn tennis. But of course I gave up because I had a problem with my elbow. I tried golf, made blunders in my swing, and dropped it. So today I just read, listen to music, and read.
And read.
Yes.
In your view, what does the future for arbitration in Kenya look like?
Very bright. Very, very bright. I mean, if you consider the period I was talking about of 1996, 94, and now there's such a big shift towards arbitration. And I can see arbitration becoming the main, or ADR generally becoming the main, right now we are calling them alternatives, but to litigation. Litigation might be the alternative in the near future, the way I look at it. And of course, the establishment of the Center for International Arbitration in Nairobi has also put us on the limelight as a country. And so I think there's a huge space for us to occupy. I read some report, I think it was done by the London Charter Institute, that said Kenya in 2023 had only 1% arbitration globally, but last year, 2024, it is at 7%,
Wow.
which means it's growing very, very fast. Within 1 year, we've shot from 1 to 7.
So, what are the necessary steps to position Kenya to being a regional hub for commercial arbitration?
Yes, the steps, as I said, we now have a center. That is, we just need to market ourselves. We need to go out there because, again, we are not very many who get these international arbitrations. There are very, very few. We need to do what I saw one of the top arbitrators in the country do, vying for those very high level positions in the arbitration, international arbitration. So we need to go out there. We need to reclaim or claim our space in the international arbitration.
What advice would you actually offer to a younger practitioner who is aspiring to come up in arbitration and also be a Supreme Court judge one day?
Right. Focus and being aggressive. Today's world is quite competitive. And so if you sit back and wait for manna to fall from heaven, you will wait forever. We must be go-getters. We must practice integrity. We have to be ethical in whatever we do. And we have to keep right company, get right mentors to help us.
That's true, I agree with that. How can the arbitration practitioners and the judiciary collaborate to actually push arbitration forward and take it to the next level in Kenya?
There are many ways, but I think first and foremost is through our decisions, our judgments, the best way to collaborate, to streamline the law on arbitration. But over and above that, we, as I've told you, there are over 15 judges from all levels of superior courts who are arbitrators. And through this, we have had occasions to interact, to give to the Institute. I personally have participated in many of the events of the Institute. Last year, I think I even graced the gala dinner. I've participated. There was also the ICC, International Arbitration Conference in Nairobi. I gave the keynote address. So there are many, many ways in which we can collaborate. And again, because judges do not go out very often to look for some of these things, it is really upon the Institute to reach out. And judges are willing and ready anytime to participate in any of their events.
Yeah. Thank you so much. The next segment, I'll just do a quick fire question, just some fun questions for people to get to know you a little bit deeper. So 5 quick fire questions. Are you early bird or a night owl?
Early bird?
Are you an early bird or a night owl?
Early bird.
Yes. What's a book that you're currently reading and that you will actually recommend?
I'm reading currently I'm trying to get the actual, it's got a long title, then the 9 Bottled Scorpions. It's a book on the 9 Supreme Court judges. And so scorpions in a bottle, can you just imagine?
Yeah.
So that's the book I'm currently reading.
Nice. What's your favorite place in Kenya to actually visit or just hang out?
The coast, Watamu.
How do you balance family and your career?
Family comes first, but I balance. My family gets more, obviously.
Yes.
But by default, my work takes more. I don't know whether you understand.
Yes.
Because I spend most of my time working, 99% more or less. You come to the office in the morning and you go home in the evening. So what time have you had with your family? Very little, but I make sure that I compensate.
Yes.
Yeah.
What's one habit that keeps you productive?
Resilience. I don't give up. I keep pushing. I try until I get it right.
Thank you so much,
Thank you.
Justice.
Thank you.
Thank you so much for your time and just sharing your insights. And I hope this episode has been impactful as it has been for me as well. Thank you so much and have a lovely day.
Thank you very, very much for this opportunity to share my views with you, and wishing you all the very best.
Thank you.
Thank you. ADR is the way to go. ADR is the only way. Karibu ADR Week.